LLC, handling criminal immigration matters in the Washington, D.C. and Maryland courts, both federal and local. She developed her criminal law expertise during 7 years with the Maryland Public Defender's Office. And Ms. Rhodes, here you go. Did you want to hook up a laptop?
I was actually going to use yours.
Yeah, sure. There you go. Yeah. Wait. Ms. Rhodes' immigration practice focuses on deportation litigation and other areas involving the effect of criminal convictions on immigration status and benefits. So let's give Laura a warm welcome. And then I'm going to steal this, and it's going to get in your materials.
So that intro is only about 10 years old, so, or a little more, because Ann Albright became a judge about 12 years ago. So then I was the founding member of my own firm.
That. And then you can use that if you like.
Thank you.
Sure. Thanks.
Hi, everybody. I know it's been a long day, and I'm a keynote speaker, right? So we have a lot to cover, actually, because immigration is a challenge.
What happened?
I don't know, I'll turn it off.
Okay.
There we
Don't
go.
do that.
Okay, DUI immigration, an unfortunate mix. And you see what I did there? It's like mix, like a mixed drink, and it's kind of blurry too, so that's about as funny as this gets today. The reason, what's interesting though about the previous presentation, followed by this, is that they both involve serious consequences and harsh and nonsensical regulations and procedures. I mean, some of the stuff I was hearing, it's ridiculous. It's sort of like, oh, well, you did this in another state, well then you're screwed. Only for immigration in this country. All right, so I'm going to start out with just a very couple of slides on some basic issues about immigration, okay? Because I know that you all have practices that don't just include DUIs. So I want to talk about some things and a little bit of good news. A lot of things you can be deported for. Any crime of violence that has a sentence of a year or more could be an aggravated felony, although Supreme Court law has changed a bunch of things, and now certainly DUI is not a crime of violence. Okay, that's been a while. But that's when you hear about, oh, it's a year or more, all these things. A year or more doesn't matter with immigration law, though. I mean, with DUIs. Another thing is that DUIs and DWIs are treated the same by immigration, and any kind of attempt is also the same as the offense for immigration purposes, as it is with motor vehicle. All right, another thing that you hear a lot about is things that make you deportable, like an aggravated felony, and this is a crime, this one shows a crime of moral turpitude, which anybody who's convicted of a crime of moral turpitude within 5 years of the date of admission, if the offense is one in which 1 year or more can be imposed. That means deportation. Even a green card holder, within the whole 5 years of their having their green card, before they naturalize, they can be deported for that. So be careful, even if you're trying to avoid a DUI, DWI, and you can get something else, like theft of a license plate, be careful it's not going to be one that's going to trigger this. Same thing with multiple crimes involving moral turpitude. 2 at any time is a deportable problem even for a green card holder, okay? A permanent resident, which is sort of the best status before, or the most protected status before citizenship. All right, so just a couple of examples about that. Now, on purpose, I crossed off deportable, removable there, and I'm going to talk briefly about a crime of moral turpitude as an inadmissibility issue. So if you're here in the US, you can be deported for a number of reasons. If you're outside the US, you can be blocked from entering for a number of reasons. So one of them is, and this you can see how broad this is, an alien convicted of, or who admits having committed, or who admits committing acts which constitute the essential elements of a CIMT. So you could have a case where the evidence is thrown out because of a bad search, but your client testified at some pre-trial hearing under oath, and that's enough, okay? So it doesn't have to be a conviction. Most of the time it does, but for this it doesn't. Fortunately, DUIs are not considered crimes of moral turpitude. So I put this definition in here: inherently base, vile, or depraved, contrary to the accepted rules or morality, and the duties owed between persons or society in general. So the Seventh Circuit, this is just from the Board of Immigration Appeals, and you can appeal from the Board of Immigration Appeals to a federal circuit court in certain circumstances. The Seventh Circuit wrote a great opinion about 10 years ago, which talked about there is no way we can define a crime of moral turpitude. And so they went through all the possibilities and said we can't do it, and so they shut down immigration's interpretation in a particular case. So I just threw this one in here as one of the many examples. But generally, for immigration purposes, it's sex offenses, and then, of course, regulatory offenses like buying alcohol for a minor. Right up there with sex offenses. Okay, this part does not have to do with DUIs specifically, but if you look at the domestic violence crimes, I just want to put a bug in everybody's head about a crime of domestic violence, because that can be its own reason for deportation, no matter the penalty that's imposed or that's a possibility, no matter the wishes of the victim or somebody else. It can make you deportable. It will. And the other thing is a protective order violation, if it is for the part of the protective order that has to do with threats and violence. In other words, if there's a protective order that covers making support payments and they violate that, that's not going to trigger immigration. All right, so the issue here is we're talking about a huge, broad category of non-citizens. So it includes this list, people who come across the border and don't, and it's called entry without inspection, EWI. Inspection meaning no official sees them, no official acknowledges their entry. Asylum, which you've all heard about, adjustment of status, that's the phrase for somebody who, let's say they're here on a student visa and they're going to, and they marry somebody and they're going to become a green card holder or a lawful permanent resident, they're adjusting their status. And then the others are people coming into the U.S. short-term, like a student or a tourist coming, or somebody coming for short-term training. Or there are some non-immigrant visas that last for 1 or 2 or 3 years. If it's something in it, like tech people who are coming to fill certain positions can do that. I'm going to talk about the other 2 categories when we get to those. All right, so the first category is undocumented persons. Oh, and you notice that I repeated something up there. A DUI conviction affects non-citizens differently depending on their immigration status, okay? So I'm going to go through now A through H of different categories. The point is that when I get a call, Henry, Sean, at 8:45 in the morning, hey, I've got a pretty good deal. It's blah, blah, blah. Can my client take that? I'm like, how the hell should I know? Okay, are they a green card holder? No. Okay, when did they come here? Do they have any status? Yeah, there was some kind of visa. Okay, when? I don't know. Okay, find out. Because it's just a million different ones. A million different possibilities, and sometimes it's like starting with this, undocumented persons. If they came with no papers and have never had any, let's say they've never had contact with immigration officially, right? They just came across the border. that's somebody you really want to protect, because if they get too deep in the system, then ICE will get a hold of them. DUIs have become a focus actually under Obama, through lobbying and lots of stuff. It became more and more of a problem for non-citizens. So if they're undocumented and they already have an ICE detainer on them, you may not be able to stop anything. They might get bond from immigration court for a while, but maybe not. So the question isn't, does it make them deportable? Because they're already deportable as an undocumented person. Not to say you can just think it doesn't matter, but I mean, there are things they would, I don't know, I would have somebody do like a right turn program, maybe do 4 weekends at right turn, so that when they come in, they can maybe get something that's less, the negligent or something else. You've got to press for anything you can do. All right, the next category here is DACA. Anybody know what DACA is? Who gets it? How do you qualify for or be eligible to apply for it?
You came here and you were a kid?
Right, you came here as a kid. You were under 16 basically when you were brought by your parents. So through no fault of yours, you don't have status. And this has been a huge fight back and forth between Congress and Congress and itself in this. So for them, they're in a very, and I'm going in the order of the most vulnerable to the most protected. So undocumented, most vulnerable. DACA is the next one, because one DUI and they're done. They'll have their DACA status withdrawn, and they can face, I made up a little list here. So lose status, detention, and stricter standard for release, lose GMC. Who knows what GMC is? Good moral character. Sorry, I'm using the abbreviations here, but good moral character crops up all over the place, and in immigration law, and deportation, which is the clever acronym LDLD. It's the best I could come up with. So TPS, temporary protected status. There are now 16 countries that we give, whose citizens we give temporary protected status to, TPS. Sudan, South Sudan, Yemen, Haiti, Honduras, all over the world, 8 more. So they're here, and you may recall, if some of you have been involved with this, Liberia, for example, got TPS for the country because of the really extreme civil war going on there a long time ago. And it stayed like that for about 11 years. So of course, nobody wants to go back after 8 years or whatever. Their kids have been raised here. And so there were some special provisions for people there. And that is controversial in terms of the Honduras and El Salvador, Central American populations, because they often have been here still with valid TPS since 91. I think the first was 91, or around then. So those are a problem, and the TPS is, you've had this status for a long time. It gives you a work permit, okay? So if you lose it, it's a problem. And if you, just any 2 misdemeanors basically will qualify. The only exception is New York has some statutes that are, you can get a 5-day, it's like some tickets, you can get up to 5 days in jail. So immigration made it, okay, if you can get more than 5 days, then it's a misdemeanor for our purposes. So that's another group to be mindful of. Then students and other people here on temporary visas. Students are probably the ones, students are often here for 4 years and they have to re-up. If a student got a DUI while they were here, it would most likely not affect them, but it could, they could have their visa revoked. And more likely though, when they leave and go home for a visit and try to come back, they could not get, it's possible they could not get in. But that again would be more likely with somebody with 2 or 3 or 4 DUIs, and there's this issue, they might say, can you prove that you don't have a mental or physical disorder, medical or physical disorder that endangers yourself or others? And so you can see how if you had some horrible accident that killed 2 people, they're going to try and invoke this. But generally, they're not going to have, it's not going to be a huge problem for them. Other temporary visas, you might be here for 3 years or even stay on longer. There's some where you can cobble together 2 3-year ones and add one, so 7 years without permanent status. And so it's the same situation. You need to warn them that this can be tricky and they're going to have a lot of documentation ready in case they're asked at a consulate when they're trying to renew their visa. Okay, so actually I'm going to back up and talk about that issue of documentation. And this applies generally to DUI cases for immigrants, for any immigrant. You want to have the lowest possible offense. You want to have the shortest possible sentence and the least burdensome sentence, or the least whatever. So in the example of having somebody do right turn 1 or 2 times, you do that so that in advance, and the treatment and everything else, you do that so that when you get into court, the judge doesn't have to impose a lot. And if the prosecutor thinks, oh, that's, this person, it's the first offense, et cetera, they've done a lot, they can maybe, but the sentence won't be as harsh. It won't sound as harsh, okay? It still has the consequences. But the reason I say that is that I have noticed over the years that immigration judges don't know jack shit about criminal law. And they have made huge extrapolations on some cases that were wildly against me and wildly in my favor, because they just don't know. And one time, a judge looked at a sentence and said, oh, well, it was 10 years, but then it was knocked down to, it was less than 3 years of suspended, or less than 3 years served. So obviously it wasn't a big deal. But it was just that the attorney who had the case, when it came back on appeal, got an incredible deal. It was kiting a $15,000 check. So anyway, but the judge thought it wasn't a big deal, so that was good for me and my client. So I always try and get, if the prosecutor insists on some time or sometimes suspended, I'll be like, okay, how about 18 days? I mean, it just sounds so small when you see it in immigration. It's like, well, the judge must not have thought much of that. So anything you can do to not have the person piled up as part of the sentence with all these things is going to make it look like a lower, like a less serious type of alcohol offense. And the reason that's important is that in a lot of areas in immigration, the judge or INS has discretion, USCIS has discretion, and they can weigh that how they want. And so that's when I use, oh, yeah, it wasn't a big deal. Let's see, the judge just gave them, I think it was 10 days suspended and, blah, blah, blah. And so they think, oh, okay, that's, not a lot. So work on that too. Don't ignore that aspect of it. Okay, so asylees are given special leeway in terms of minor offenses. And this would be, a minor offense that they would probably not have an issue with coming through the asylum office or in court. Partly because what they have been through is usually so horrific that you would be surprised if they didn't have a DUI once they got here. And withholding of removal is something that's sort of rare, where I have a client who had a murder. And she, after serving 20-some years, got out and was granted, well, she had actually already gotten withholding of removal because she was able to establish that as a lesbian from a Middle Eastern country, she would face death, basically, in her country. So in spite of the offense, she gets withholding, which allows, and if the country conditions ever change there, she can then be deported there. But it's not likely. But she can get she has a work permit, but that's it. So she really can't travel at all, and she can never get a green card, or back, she had a green card. She can never get one again for citizenship. Okay, so this list is in a different order from something I have in the materials, which is an OPD, thank you, Sean, for sending that around, an OPD flyer about consequences for DUIs. And the person, was Nadine Wetstein and edited by Maureen Sweeney at the University of Maryland, had done this list. I think that somebody applying for LPR status, again, as an asylee, is the person who's already been granted asylum. I think it's not that likely they would have a problem with one DUI. And that's speaking for sort of what I see in Maryland and Virginia, which covers DC, Virginia. So, you know, there are places in the country where judges would just gleefully shut down somebody getting their green card for one DUI. And you need the proof of rehabilitation. You need to show, and I make sort of a list or a chart, 26 weeks of this program, and this program is certified by the state of Maryland, hype it up. So that kind of stuff will help, as I mentioned before, but I'm going to harp on it. Okay, so this is a special category that even people who have no status here can get. It's called non-permanent resident cancellation of removal, which is basically just what they call the new version of your one shot that maybe you could get not deported. The issue is really, a DUI is kind of the least of your worries in this scenario. I mean, it is a problem because it weighs against good moral character under immigration law. But the hardest thing to do is this. You have to prove exceptional and extremely unusual hardship to a U.S. citizen or permanent resident family member. That means not the ordinary hardship of being away from your family, not the ordinary hardship that they'll have no income from the primary breadwinner, maybe, not the ordinary hardship of never getting to see your kids again, or in 20 years, etc. All those are ordinary. So really for this, you need a sick child or a sick spouse, and very sick, because they'll just, piece it to death to see no, this person could get treatment. We found a hospital in Kinshasa where she could go for this treatment of her melanoma, even though the World Health Organization says she can't. So, okay, the other thing here too, and it goes for other categories, is that you need to show that it was an aberration, ideally. Show that there was trauma, something was happening, something was going on, like you do in front of a criminal judge. And that's why it happened, but it's not likely to happen again. Certified copies, all of that, have to have them. Also, I never, ever, ever send immigration a statement of charges or a police report, DUI or anything. You don't have to. And they will ask for it. They'll say, please send a police report. Don't do it. They never look good. The raw, just kind of that basic, DUI, blah, 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 200, 6 months suspended, A, B, blah, blah, blah. It's like, nobody cares. It's just, it doesn't come to life. But the statement of charges with the person urinating in the seat is like, not, maybe a good moral character issue, I don't know. All right, so, how much time do I have left?
However much you need.
Okay. So, okay, residents and, so yes, we have some good news. If you're a permanent resident, you can't be deported just for a DUI. It's not an aggravated felony, and it's not a crime of moral turpitude. Again, though, nothing's ever clean. The inadmissibility can be a problem. Okay, so you can leave the country, and if they think, again, back to that issue of you have a disorder that is related to your, and your behavior is exhibiting something from that disorder that could cause harm to you or others, then they could block you. That would be pretty unusual, but it's still a concern. I would have a client travel with all their rehabilitation stuff. I would do a letter. I'd have to do a letter to Customs and Border Protection saying, please allow this person in, and just 8 exhibits of stuff they've done, so that it reduces any potential problem. Citizenship. Somebody can say to you, I've got a green card, I've had a green card for a long time. Great. Do you, have you tried to naturalize? What's the situation there? Because once they do this, once they have a DUI, they pretty much can't naturalize for 5 years. depending on some other circumstances, but it used to be in Maryland you couldn't, they would, you know, count the days. It had to be exactly 5 years or more before your interview date for citizenship, or they later started saying, well, okay, if you're still on probation during that 5-year period, that's okay because the offense was earlier. But Virginia was always pretty easy with DUIs. I don't know how, that's more like 10 years ago. I'm not sure if they've changed much, but I guess I had one like 7 years ago there, a naturalization where they didn't care. And again, just because this isn't confusing enough, you also can't have not any more than 180 days in custody during your 5-year period of good moral character. Which probably, one of them is going to be a problem. All right.
Laura,
Yeah.
so if it's 181 days and it's a DUI on a green card, what's going to happen?
Oops, I went the wrong way. Anyway, if it's 181 days and it's a green
card
card
on a DUI.
trying to get natsed,
Yeah.
well, you could just wait till one of those days is past the 5-year mark. In other words, you can apply, once you've had your green card, well, once you're eligible to apply for citizenship, they're going to back up 5 years, right? So if that 180 days is within that period, then you just have to wait maybe a month until the end of that 180 days is off the 5-year thing. Make sense? So it's a sliding, so your character gets better as the time goes on, in theory. Okay. So, all right, are there any questions? Yeah.
If someone who's considered a stayover, meaning they came in with some sort of temporary visa and then they just stayed and started working, would they be treated the same as someone who's undocumented? I mean, always.
Well, they're sort of one step above that because they came on a visa. And so if you came on a visa and you married a U.S. citizen, or a U.S. citizen parent petitions for you, if you happen to have that, you don't have to go back to your country and come back in again, so you avoid facing a 10-year bar by doing that. So yeah, there is some benefit to that. Anybody else have questions about the different categories? No, okay. So, okay, now I'm going to talk about, this gets to the really good news of the new PBJ stuff. What does the immigration law say a conviction is, okay? So it's a formal judgment of guilt entered by the court, or if adjudication is withheld, the judge or the jury makes a finding of guilt, the defendant enters a plea of guilty or nolo, or the defendant admitted sufficient facts to support a conviction. This actually was a law, they modified this because of our PBJ in Maryland. So the case was Oscott, it was like 1989 or something, and so they didn't like the fact that we had that. And so this is what it was, because now you can see, or if adjudication is withheld, these things, you know, one of these is going to happen. And the problem with the Maryland statute was that a judge makes the finding and then suspends it. And there are other states that have situations where they don't make the finding, they just have it there and hold it, like Virginia. So, yeah, so you also got other sort of times they could admit something like that. So the other part of it was that the judge had to order some kind of punishment, penalty, restraint on liberties. Unfortunately, it didn't come out. Oh, it's fancy. I don't know. I didn't do this, I swear.
No one else did.
It's shit. I don't know. It was a mistake. Any of these, including paying a fine. Now, I think there was even a case where they said if you just paid court costs, that still counts. That makes it a conviction. So it was ridiculously strict. And now we have Maryland PBJ. I call it Maryland PBJ 2.0. Because it knocked out the first parts of the first prong, right? So the judge or the jury is not finding the defendant guilty, and I'm going to go through the statute if there is time for that in a minute. the defendant enters a plea of guilty or nolo contendere. No, under the new statute, the defendant is pleading not guilty. And admits sufficient facts to support, no, he doesn't, the defendant doesn't admit facts to support a conviction. So the next one doesn't matter, the next prong doesn't really matter because we don't have that finding. So the judge can order restraints then. And restraints, whoops. Oh, okay, so this hasn't been signed by the governor yet, but everybody expects it will be. And this is the statute, so I'm going to...
Go ahead, and it's effective October 1st.
Right, right. So when the defendant pleads not guilty, the defendant may, with the consent of the state. Now, this was a last-minute addition, you know, hugely fought over, but it's in. So with the consent of the state, enter into an agreement with the state under this subsection, and the court may find facts justifying a finding of guilt beyond a reasonable doubt, defer entry of a conviction, and place the defendant on probation before judgment. So, and this is sort of standard stuff, you know, it has to be in the best interest of the defendant and the public welfare, same as the old PBJ, and defendant consents in writing. Now, here's the thing that is harsh about it, is that if the defendant violates this, the court can enter a finding of guilt and impose a sentence. So there's no redo, you never get a trial. So be aware of that. I mean, it may be, you know, it's sort of essential for somebody who's an immigrant, but it may not be for other people if they may, you think they're very likely to violate. So, okay, so the provisions are the defendant doesn't admit the facts offered by the state and pleads not guilty. The defendant accepts probation in exchange for the court expressly withholding a finding of guilt. So that if an immigration court says we don't buy this, then they can't use the conviction. I mean, we go back and vacate the conviction because it's, I don't know, it's not. So then the defendant, okay, waives trial right, as we said, and the right to appeal the probation agreement. Okay. The defendant still can appeal the violation itself. Okay. If the court finds that the violation, then they can find the defendant guilty and okay. Okay, yeah, so this part at the end here is very important. So when they have found that there are sufficient facts for a finding of guilt, but the court does not do so and instead defers judgment and imposes probation before judgment. So it should be very clear and a huge signal to immigration that don't touch this. We'll see. This language comes out of a Virginia case that went to the Fourth Circuit, Crespo versus Holder, and it they had a system kind of like this one, and it passed muster at the Fourth Circuit. So that's how this one kind of came about, looking at that. And okay, so Gabriella Carl gets all the credit for this PBJ bill. She's worked on it forever and got retired federal judges, retired immigration judges, everybody beating this issue for a long time. So I thought I'd give her some credit. Yeah.
I have a question. So with the new PBJ, I guess, law, if technically, I mean, I'm guessing they're not making a fine on the record. If they successfully complete their probationary period, will they be eligible for an expungement on a DUI? Or do we know how the eligibility for expungements work with this new PBJ?
You know, I don't know that.
Well, but there's language in the bill that says that it's treated as a PBJ. I forget exactly
That's
the
true.
exact
It's
language.
everything else
It's
is
treated
like
as a PBJ is
yeah.
treated now, and the expungement statute does not allow expungements for DUI PBJs.
Okay, perfect.
Is there going to be a specific, like, say, script to make sure judges don't mess this up, prosecutors don't mess this up?
I think I would probably take a copy of the statute with you and say, but Your Honor, you're saying that you are not imposing a finding of guilt, correct? And
It seems like something
You would think the court is going to have a form, and you just check off the lines and sign at the bottom.
So
I think that's what they're going to have to do.
about a year and a half ago, when this was up, I drafted a form and said, like, this, because some prosecutors signed on, Montgomery County and PG County did at different points and whatever. I said, look, we're not hiding anything, here's what it would be, but that never took off, so maybe they're going to do it. I don't know. Any other questions?
Well, the state's attorney has to agree to it, right?
Right.
So have the county state's attorneys taken different positions? Are they going to go?
No, I mean, in terms of the passage of the bill, there were several prosecutors, in fact, not this year, but last year, the Maryland Association of District Attorneys, or whatever it's called, supported it. This year they didn't, but McCarthy had said he supported it, and in Montgomery County, and also Brooks said.
Angela also Brooks.
Yeah, also Brooks in Prince George's
So
County.
what class of offender?
Well, I mean, they supported the bill, so they thought that people should be eligible for this. I think it's going to be, I mean, how it plays out is going to be.
I mean, you would think that if they're going to agree to a PBJ and the person has immigration issues, it
Right.
would seem they're going to agree to this,
Yeah, right.
right?
Although they can.
Well, you would hope.
Yeah, you would.
I mean, they can oppose it though, and the judge overrules it, so we don't have that option now, which is.
Right.
Seems like that they may have just been agreeing that it requires their consent for it to happen, as opposed to them actually agreeing with the bill.
We'll see.
Do we have like another name for this kind of agreement? Like, so that it's not confused with the post?
It's in the same statute.
Okay.
It's
Yeah.
sort of, I don't know, there was some talk about,
Yeah.
Not guilty, PBJ?
yeah, I mean, PBJ
Yeah.
2.0, call it that.
Right, there needs to be something.
Yeah. We better come up with a name, otherwise it's going to be something
Yeah,
bad.
all right.
Yeah, yeah.
Are you done?
Yeah. anything
All right, well,
else?
hey, Laura, thank you very much. Let's give her
Yeah.